welcome to the next episode of the Kingsley Napley Quarter Protection Team podcast, empowering minds and protecting lives. I'm here with my colleague Lauren Eyre, and we're going to talk about Health and Welfare Deputyships. Hi Lauren.
Hi. So, what decisions can a Health and Welfare Deputy make?
If a person is unable to make decisions regarding their welfare, such as where they live, who they live with, their care arrangements, medical and dental treatment, and their leisure and social activities, then they may need the court to appoint a deputy to make those decisions for them on their behalf.
Who can apply to be appointed as a Health and Welfare Deputy?
Well, Lauren, any person over the age of 18 can apply to be a deputy. They cannot be paid for the work they do though, so the person has to really consider whether this is the kind of job they want to take on, as there'll be a lot of work involved. They can claim any reasonable expenses that they incur. When a child reaches the age of 18, their parents no longer have what's called parental responsibility to make decisions about their health and welfare for them. This is a problem for parents of children who will never have mental capacity. Once their child turns 18, a public body, such as a local authority or NHS trust, take the lead responsibility for making those decisions. There is often conflict between the parents and authorities, and the parents feel excluded. So this is why they will apply to have a deputyship.
How are decisions made for people who don't have a personal welfare deputy?
In cases where there's no personal welfare deputy, Section 5 of the Mental Capacity Act applies. This section is designed to provide protection from liability so that carers can act in connection with a person's care or treatment and make certain decisions for them without the need for a deputyship. There's a long list of actions that might be covered by Section 5, and these include personal care, such as helping with washing, dressing or personal hygiene, helping with eating and drinking, helping with communication, helping with mobility, helping someone take part in education, social or leisure activities, going into a person's home to drop off shopping or check on them, doing the shopping for them or buying necessary goods for them with their money, arranging household services, providing services that help around the home, undertaking actions relating to community care services, helping someone to move home. And in respect of healthcare and medical treatment, the kind of decisions a carer can make on another person's behalf without a deputyship include carrying out diagnostic examinations and tests, providing professional medical, dental and similar treatment, giving medication, taking somebody to hospital for assessment or treatment, and providing nursing care.
And when will the court be more likely to authorise an appointment of a Health and Welfare Deputy?
Well, Lauren, the court doesn't really like making health and welfare deputyships. It actually prefers to make a one-off decision in respect of a person's health and welfare rather than appointing a deputy, because it's really concerned about promoting a person's autonomy. That's like their own decision making and their independence. However, where somebody has really complex needs and lots of decisions have to be made over a quick period of time, then an application should be made. When the person makes that application in those circumstances, they'll need to show that it would not be helpful to require all those decisions to be made by the court in separate applications, which can be time-consuming and costly. The application should provide evidence that the working relationship between the applicant and the authorities who are allowed to make the decision at the moment is not allowing the person involved to be properly supported and is not in their best interests.
So how do I apply to become a Health and Welfare Deputy?
Well, the application for deputyship includes the completion of paperwork for the court. There's a statement of the person's personal circumstances. You'll need a medical certificate stating that they don't have capacity to make decisions about their personal welfare. And the deputy will need to make a declaration confirming that they will act in the person's best interests at all times. These will need to be fully completed and returned to the Court of Protection with the application fee. In certain circumstances, the fee can be waived if it can be shown that the fee would cause hardship.